Hello, everyone. Welcome to our webinar, Chinese Law and the Global Development of Past and Present and the Future Analysis. My name is Enshen Lei, and I'm a senior lecturer at the School of Law, the University of Queensland. So the webinar is being co-hosted by the School of Law, the University of Queensland, and the Center for Chinese and Comparative Law, City University of Hong Kong. So today's seminar aims to highlight China's legal landscape and effects on key areas of law, such as criminal law, constitutional law, economic law, and copyright law, and others, to explore the country's contribution and impact as China rising as an important regional and global power in recent years. So the seminar will be delivered in two key streams. So the criminal law session in the morning and the international and commercial law session in the afternoon. I would like to start today by acknowledging the traditional owners and their custodianship of the lands on which we meet today. On behalf of the University of Queensland, I pay our respects to their ancestors and their descendants who continue culturally and the spiritual connections to country, and we recognize their valuable contributions to Australian and the global society. So for the first session, we are honored to have Professor Liu Jianhong, Professor Sutra Vasquez, and Professor Liang Bing as our speakers. So Professor Liu is a distinguished professor of the Faculty of Law at the University of Macau. So he's the winner of several distinguished international scholar awards in the American Society of Criminology and the Academy of Criminal Justice Sciences in the United States. So he's currently elected the president of Scientific Commission of the International Society for Criminology, elected the chairman of the General Assembly of the Asian Criminological Society, and the member of the steering committee of the Campbell Collaboration's Crime and Justice Group. So Professor Liu is the founding and honorary president of Asian Criminological Society. So our second speaker today is Professor Sutra Vasquez. So Su is a professor of Chinese studies at Griffith University. So her research has resulted in over 60 publications, including the first books in English on criminal courts in contemporary China, policing serious crime in China, and the death penalty reform in China. Su has published numerous books on the Chinese justice in leading journals, including the China Journal, the British Journal of the Criminology, the China Quarterly, and Modern China. So she has also co-edited volumes on China-related topics, including the politics of law and the stability in China, legal reforms and the privation of liberty in contemporary China, justice, the China experience, and the most recent book, The Party and the Law in China, Ideology and Organization. So our third speaker is Professor Liang Bing, who is a professor of sociology at Oklahoma State University. Professor Liang is the author of a number of the published books, including The Changing Chinese Legal System 1978 to Present, Centralization of Power and the Rationalization of the Legal System with Routledge, China's Drug Practices and the Policies, Regulating Controlled Substances in the Global Context with Ashgate, The Death Penalty in China, Policy, Practice and Reform with Columbia University Press, and the most recent book, The Chinese Citizens' Opinions on Death Penalty, death sentences and Empirical Examination with the University of the Michigan Press. Professor Liang is also the president of the Association of the Chinese Criminology and the Criminal Justice in the United States. So the fourth speaker is myself. I'm a senior lecturer at the School of Law, the University of Queensland. So my research focuses on criminal law, criminal procedure, socio-legal studies with a special focus on the Chinese criminal justice system. And I had practiced criminal law in Shanghai for a number of years before I became an academic. So today's session, the criminal law session, will involve 20-minute presentations from each of our speakers. And if you have any questions, please add them to the Q&A section, and we will address your questions in the Q&A time.
Look, I'd like to talk today about one particular aspect of criminal justice in China at the moment, not the death penalty, which is what I usually talk about, but the other end of the spectrum, which is 社会治理, which is something called social governance in China. So I wanted today to talk about one aspect of social governance, and that is its comprehensiveness in the discourse. The idea about social governance as a comprehensive way of governing society. I'll end this talk with this a spot the difference type conclusion, looking at the difference between the 1981 concept of comprehensive management of public order and the 2021 idea, 40 years later, of comprehensive social governance. So if you're listening to this and you're not a Chinese politics scholar, you may be thinking, so what? What is the benefit of comparing something that occurred 40 years ago to something that's happening today? I suspect that those of you who are interested in Chinese politics and follow Chinese politics will probably know the answer to this, and that is that in the Chinese political landscape, party authorities need to be able to demonstrate the bloodline from one socialist policy to another to be able to show its legitimacy. So to put this conversation in the context of the whole politics of this, I want to begin by placing the concept of social governance and the move to promote it as a comprehensive endeavour firmly in the zone of ideology, because that's where it sits. This is because social governance is first and foremost rationalised in terms of socialist ideology. So since ideology is mainly practiced through discourse, a shift in language, especially the language of governance in China, is an especially significant way to gauge changing frameworks of action. As a framing device, socialist governance terminology signals, not just to the public, but to millions of government functionaries spread across China, across provinces far and wide, it signals changes in the way that governance is to be approached from one political era to another, or new directions within a political period. So in the Xi Jinping period, there's been a particularly active engagement in ideological catchphrases. One of the most notable in-party Congress documents and plans has been the phrase, and Rose, would you mind moving to the next slide? Thanks, Rose. Excellent. Has been the phrase modernization of governance capacity, which was first touted at the 18th Party Congress in 2013. So there's this prominent China scholar called Wu Guoguang, and he notes that Xi Jinping himself chose the theme of modernizing governance capacity as a centerpiece term in the fourth plenum of the 19th Party Congress in 2019, because Xi Jinping says it provides an institutional guarantee for actualizing or realizing the China dream. So so social governance is absolutely connected to the highest policy priorities in China. So social governance is a term that broadly refers to two things that come together. One is managing social security and social support on the one hand, and then social stability on the other, or more precisely, social instability on the other. So if modernizing governance capacity is supposed to actualize or realize the Chinese dream, then we might like to say that social governance actualizes one important part of modernizing governance capacity in China, and that is the capacity of the party state to see society, to see the whole of society, to make society transparent to itself, to monitor and to respond preemptively to social instabilities. So according to the party's main law and order leaders, authorities who are authorities in the Zhengfawei, in the Central Political Legal Committee, in late 2020, they said in order to promote the modernization of social governance capacity, it's necessary to improve the system itself by making social governance more comprehensive in nature. So I want to dig a little deeper here into the language of comprehensiveness in Xi Jinping's social governance agenda, and more specifically, how the party says it's building a more comprehensive system of social governance. So I find this claim of holistic comprehensiveness is now being made more ideologically plausible through reconceptualizing China's governance narrative that supports the use of emerging technology while enabling society to be enabling society to be more transparent to the party. Okay, so the party calls this something, it calls it smart governance, 智智, okay? Now, I want to talk about the language of social governance in relation to smart governance, and then go on to talk about its claims of comprehensiveness. And then finally, I'll go back to 1981. And I want to acknowledge at this point that the majority of information I'm going to talk about in terms of the technology and surveillance, it comes from a draft paper that my colleague, Ozma Burnett, and I are writing at the moment on smart governance. So I'd like to acknowledge Ozma here. According to Xi Jinping, modernizing governance capacity provides a concrete institutional framework for the China dream of national rejuvenation. So it's included in the centerpiece plans, all of the party's centerpiece plans, and it builds on this existing idea of Internet Plus initiatives. So Internet Plus uses big data innovations in cloud computing, the Internet of Things, and also mobile internet to improve government services to the public and market regulation for economic growth, and to strengthen supervision and management processes. From the years 2021 to 2025, big data, apparently, according to the party, will also enhance a vast array of existing e-governance platforms that aim to make citizens' interactions with government, especially at the local levels, much smoother. Initiatives include, for instance, the provision of smart apps that improve access to government services and social benefits, especially for the disadvantaged and the vulnerable people in China, such as the rollout of digital security cards for migrant workers. So that's a good thing. So smart governance is making government service functions and processes increasingly transparent to society, but it's also making society increasingly transparent to the party. Improving provision of health, financial, administrative, and other services through cloud-based e-governance makes the behavior of governing authorities relatively less bureaucratic and more transparent to citizens. But on the other side of the transparency coin is the development of a vast array of cloud-based databases and other tools for Internet Plus monitoring. These online tools are used to detect and punish undesirable behaviours and to predict and prevent criminal or illegal behaviour. Increasingly, it also aims to mould all citizens, good or bad, to the ideological contours of what the party calls socialist core values. My co-author, Ozma Burnett, and I are finding that digital provision of social services works in symbiosis with surveillance technology to build the party state's governance capacity, especially when it comes to monitoring what the party calls target populations or 重点人口, including drug users, prostitutes, political dissidents, and others. The party's vision, that is its promise to the people, is to realise the China dream. For this grand vision to be realised, the party state wants to mould and shape all social and economic activity by leading over everything, 领导一切. Okay, now I'm going to come back to this 领导一切 idea right at the conclusion. So I'm going to come, but I want to say this first. In order to lead over everything, as I said before, the party needs to see everything. Okay, now, because when you link this back to politics, part of the China dream of a life of harmony and prosperity requires that the party state expand government services and improve accountability through greater transparency. But the precondition for this is the precondition for living the China dream of a good life is that there needs to be social stability. So that's where there's a connection between the China dream and social stability. So sustaining social stability locks the party into this ever-expanding social governance, initiatives that monitor and control the movement and behaviours of citizens. These days, the organisational approach to community surveillance is through the system of grid management. I'm not actually going to talk about grid management, I don't have time, but if you did want to look into it more yourself, there's a really easy to read paper by Ming-Sin Pei in the China Leadership Monitor, if you're interested in knowing more about that. Yeah, so that's just one aspect of smart governance. social governance. Now, smart governance is central to the party state's efforts to detect and punish what it's called undesirable behaviours. And a key focus of smart governance is the requirement of police, government and party organisations all together at the local level to combine their efforts to resolve social contradictions. And if you know anything about criminal justice in China, you know that that term's been around for 78 or 80 years. Now, in September 2021, one of China's most senior law and order leaders, Chen Yixin, who is at the moment the Secretary General of the Zhongfawei, the party's political legal committee, which controls all law and order in China, he urged grassroots authorities to facilitate the extension of smart platforms as part of what is called the Snowbright project. Now, as Ozma and I explain in more detail in our paper, the Snowbright project is an automated system of smart surveillance that taps into a network of smart video surveillance cameras, sharp eyes. Snowbright incorporates a network of smart surveillance cameras that can talk to each other in an intelligent way. And that's called data fusion. It melds together information from various sources through AI. And that's a process in Chinese called visualization. Okay. The Central Party Committee and State Council opinions on strengthening the modernization of governance capacity that they issued in July 2021 states that the main goals of the party state in governance capacity building in the coming years is to establish a grassroots governance system that encompasses a comprehensive array of smart governance. This idea in 2021 follows a line of statements made by Chen Yixin since 2019 about this idea of comprehensiveness. And the need to integrate smart governance with political governance and rule of law and moral governance and all types of these different types of governance in 2021 was made by Chen Yixin at this forum in southern China. And he made an appearance to stress the importance of resolving contradictions by doing two things. And those, again, who know about criminal justice in China won't be surprised at this. By striking hard, yanda, like criminal offenders on the one hand, on the one end of the spectrum, and preventing crime and educating people and preventing instability at the other end of the spectrum. Okay, so he identified as one of his main keywords in his speech this idea of striking hard, and also this idea of harmonizing or regulating or tiaozhang contradictions and conflicts. So again, that means something to people to students of Chinese history who can see these bloodline being developed here. Okay, so through the vehicle of party governance leadership, now that's interesting. He's saying this all has to happen in a comprehensive way through this vehicle of everything has to go, through this vehicle of party governance leadership, all of this comprehensiveness happens. So for those of you who have studied Chinese justice in the Mao and post-Mao era, you'll be thoroughly aware that those ideas about resolving social contradictions come straight from Mao. So according to Mao, contradictions that impact social order or the public order need to be resolved in one of two ways. Either you divide and you break up criminals into two groups. You separate the less severe treatment given to individuals from the proletariat, working class, and you don't strike hard at them. You educate and you prevent crime. So you push them through a re-education through labour strain. And then with those enemies, people who are defined as enemies of the people, you strike hard at them. That language is still around today. So politico-legal authorities in September in 2021 implored local policing authorities to strike hard on the one hand and prevent crime on the other. So that's all very interesting. So for me, someone who's looked at Chinese history of criminal justice, and so I want to conclude by making some observations about this kind of back to the future moment. In 1981, this new policy, it was brand new then, a new policy called Comprehensive Management of Public Order, 社会治安总和治理, made its debut in China. It was promulgated as a key ideological and organizational tool for crime in this new Deng Xiaoping era. So it's a brand new in the Deng Xiaoping era. It was developed as an all-encompassing policy, emphasizing education and punishment of criminals through various means like mutual coordination between the police and the procurator and the courts, and also through educational and cultural bodies. The ideological and organizational rationale for comprehensive management of public order, it has its roots way back in the Mao era, during the campaign era of the 1950s. So the promotion of this 1980s version of a flexible approach to criminal justice came about in the wake of this official assessment in the 1980s, a reassessment of the nature of crime and the concept of crime. And it went from an interpretation of crime as essentially class-based in nature to one that's a social phenomenon. Can I just get you to move to the next slide? Thanks, Rose. Sorry, just looking at that. Yep, there we are, good. So the emergence and increase in crime in the post-1978 era was seen as increasingly influenced, and this is important, by a whole lot of different types of social factors, economic, political, cultural. Okay, so this movement and this idea of crime from political to social is important here. The multifaceted nature of crime required a multifaceted response through various institutions. And that's another the issue I'm trying to get to here, that this comprehensiveness was about the nature of crime and how you are to respond. So the term comprehensive management of public order was a scientific term, actually. It was appropriated from the technical field of water conservancy. The rationale behind the policy was the assumption that because a criminal behavior was a complex social phenomena, and because its causes were equally complex, politically, economically, ideologically, and culturally, this social illness or this social syndrome must be cured in a comprehensive manner with the participation of all sectors of society. The policy was touted as a means of combining attack and prevent, as I've just said, combining punishment and education in order to prevent crime. Public security and administrative and educational organizations would handle the education aspect, and then the criminal justice agencies would handle the punishment aspect. Now, this brings me back to the kind of back to the future comment that I made. The similarities between the kinds of language that Chen Yixin is making in 2021 and this 1980s language of comprehensive management of public order. Now, those similarities are stark. There, you can see the connection, you can see the bloodline. But there's also important points of departure. And in many ways, I think the points of departure, the differences are even more interesting than the similarities. In the early 1980s, China was still reeling from the Cultural Revolution. And while tough on crime was indeed a motif of Deng Xiaoping's leadership at the time, Deng had to strike this fine balance between an emphasis on party leadership and an emphasis on the people, right? Not making the dictatorship of the proletariat a weapon against the people. That was an important thing. Invoking the utmost centrality of party leadership over everything, 等是领导一切, wasn't actually the language of the stark language of the 1980s, but it's become the language of today, as we know. So in the 1980s, party leadership was certainly a requirement of comprehensive management of social order. I'm not denying that. But back in the early 80s, in the early Deng Xiaoping era, responding to crime required a less rhetorical emphasis than it does today on the importance of the leadership of the party over everything. So while the leadership of the party has also been an ideological and real life presence in criminal justice forever, since the 1980s to now, it's much more integral to the ideological and real life fabric of social governance today in 2021. So in 1981, the emphasis on comprehensiveness was on the social nature of crime, and that's why they had to respond in a comprehensive way. Now, so when we hear the party talking about comprehensiveness or holistic social governance in 2021, they're talking about I think, a different kind of comprehensiveness. Yes, it definitely has to do with comprehensiveness of technology scope to be able to comprehensively see everything. That's no doubt that's the case. But there is more to it than that, I think. I think in the 1980s, the idea of comprehensiveness gave recognition to the myriad social factors that contribute to crime and illegal behaviour. But in 2021, the emphasis on comprehensiveness is not an emphasis on the social nature of crime, but on the comprehensiveness of technology together with the comprehensiveness of the leadership of the party state. Comprehensiveness or totality of party leadership over everything is what I think is a really important point of departure. Okay, I'll leave it at that. So what we find here with the smart governance initiatives across China today, and you'll see this on the websites of all the local zhangfawei, is a self-proclaimed and absolute and overwhelming necessity of the party to lead comprehensively, holistically, and totally over everything. Okay, and that's the end. I hope I didn't go over. And thank you for listening to me. And I'd like to introduce the next speaker. I think we're going back to Liu Jianhong. I think that's right. And thanks for listening, everyone. Thanks.
Okay, next slide, please. Rose, go to the next slide, please. Yes. Okay, I've mentioned that one thing to make the criminology and criminal law scholars to move forward is to go back to the basics. So what is criminology and what is criminal law scholarship? Okay. Next slide, please. Next slide, please. Okay, we see there are shared similarities. First of all, what is the criminology theory from Beccaria and Bentham? The theory is actually very simple. The theory is that people have free will, so they make rational choice. So criminal behavior is a rational choice by people. So this is criminology. Then if they choose to commit crime, then they should take criminal responsibility. So this is criminal law. So it's quite clear here at the very beginning, criminology and criminal law is combined into this one school we call classical school of criminology. Next slide, please. Then it comes to in the 19th century, the Italian school, okay, it's a positivist school of criminology. The primary people here are Lombroso, Furey, Garofalo, and the common feature of their work is to emphasize crime is not just a rational choice. Crime has many causes. There are psychological causes, biological causes, social structural causes, and so on. So they are really outside of the people, out of people's control to some extent or to a large extent. Therefore, criminal should be treated rather than punished, because this is really essentially, it is not their choice to commit crime. It is their circumstances, the other factors, multiple factors. So this is the main different theory about the causes of crime that tells people that this is really a criminology theory. And the most important thing is that the positivists believe only way to study the crime and criminal behavior is to use scientific methodology. So empirical methods is stressed and introduced. That's why they call it positivist school of criminology. Therefore, many people consider this is real origin of criminology. Next slide, please. So coming back to all these fundamental original thinkers, we had some better ideas about what really is the criminology differences and overlapping with criminal law. So at least at a very early time, that was the situation. Okay. Go to the next slide, please. Okay. So here we summarize the differences between criminology and criminal law. First of all, the objectives or the focuses for criminology is control crime. To control crime, you need to understand crime, and then you need to provide policy response. And criminal law's focus is punish criminal acts. If anybody has ever taught or read criminal law, you understand that the focus really is on the punishment. Okay, you need to attribute the criminal's responsibility for a particular crime and assign them appropriate and proportionate punishment. That is the central focus of criminal law. So these two disciplines is different in their objectives. And the ideas behind their objectives for criminology is to control crime, but for criminal law is to rule by law and is to emphasize fairness. Okay. And discipline, in terms of the discipline, criminology has been studied by multiple discipline people because the factors of influence crime are multiple. Therefore, it's an interdisciplinary science, but criminal law, in contrast, is largely a normative discipline. Okay. Next is research subjects. So, okay. So people are not so sure about, particularly criminal law scholars, not very often familiar with what criminologists colleagues are doing. So we summarize very briefly here. You know, there are multiple things that current criminologists do a lot. You know, first of all, patterns of crime, right? Criminal statistics, and then theories, particularly about causes of crime. Of course, there are other theories. And then criminal justice, police, courts, corrections, restorative justice. And then juvenile justice is a big area in criminology. And crime prevention is a big topic. And particularly in today, criminologists emphasize evidence-based crime policy. There's so much work done on evidence-based crime policy and using sophisticated empirical methods to analyze data, collect data, and provide policy suggestions. Then victimization is another part of the criminology today. Is getting bigger. And also criminologists study crimes, different type of crimes. Some of the crimes are just coming new, such as cybercrime, right? Of course, when I say new, it's not really new. I mean, it's just comparatively compared to the traditional street crimes. Those are the crimes that are relatively new. Okay. Then comparative criminology, the international criminology, people study to broaden their views. And particularly in criminology, people advance continuously with their research methods, particularly advanced statistics and also qualitative methods. Next page. So, I mean, the criminal law scholars, now, if they have an idea about what criminology is, they sort of like felt like how much that is really linked to criminal law, right? And in fact, many ideas in criminology from the very beginning to today continue to influence criminal law. The first one is criminological contributions, is the theoretical contributions. In criminal law, we talk about punishment and how to make punishment fair and proportionate, accurate. But in criminology, people talk about crime control. And one of the famous jurists, Herbert Becker, perhaps breaks this out. You know, he talks about as a lawyer and a jurist. He started to talk about in 1940, 1964. There's actually two models that working in criminal law area. One is the due process model, which is the most basic model. However, in addition to that, Becker noticed that many Buddhist police, courts, judges actually have their own ideas about other factors that influence criminal behavior and their punishment. So he bring up the other model that really is working in these jurists' minds. It's called crime control model. Crime control, we're coming back to criminology. So therefore, criminology theories indeed influence criminal law. Next page. Okay. Then the most significant feature, most striking feature of criminology, as I mentioned, is empirical methods. Okay. Criminology from Lombroso, from Italian school, talks about the positivist school, talks about criminology as a science, as a social science. Therefore, they push empirical methods, push observations, objective observations. Therefore, those ideas actually influenced criminal law from many years ago. In the West, in 1990s, people started to talk about apply the legal system with statistics, right? And then there's so many years ago, US government started to publish routinely statistics and court cases. And in the 20s, 30s, criminology start to conduct crime surveys. As we know today, crime survey has already become a standard method for many, many countries, collecting phenomena, accurate description of different crimes. And since mid-60s, empirical methods become more widely used. And there comes to these two prominent movements. One is law and society movement, and the other is law and economics movement. In different fields, people study law. Those are social scientists, and they are legal scholars. They combine themselves together to study using empirical methods to study their subjects. Around 2000, and more empirical legal studies are conducted in criminal law. So this is in law school, it's called empirical legal studies. Next page. The third influence of criminology we can see is the change, the idea of change from deterrence to rehabilitation. This has been primarily influential in the 60s and 70s, of course, from the very early time of criminology started. As I mentioned before, from the very early time, criminologists emphasize multiple factors influence people's criminal behavior. It's not just a rational choice. Therefore, deterrence is not the way to really control crime. Rehabilitation is more appropriate. So this is transforming ideas of punishment in criminal law. This has been widely accepted, actually, despite if you go to law school, you hear people talk about criminal law, the primary idea is still like a free will. However, in practice, in criminal justice, in legislation, you see more and more ideas that is not based on free will, not based on many traditional fundamental criminal law assumptions. Next. The other transform ideas of punishment in criminal law, influenced by criminal law or influenced by criminology, is emphasize the differences between criminals, differences between crimes. Okay, so the specific punishment for specific criminals, this is apparently different from like free will as only cause of crime, and everybody's equal, should be equally treated, equally punished if they commit the same crime. These basic criminal law ideas is actually changed, modified by criminology ideas that says the criminal offenders are different. For example, in juvenile justices, right? The juvenile justice is established all over the world, right? Apparently, they see the difference between children and older criminals. In many early 90s, for example, even before that, that was not the situation. Repeated offenders were treated the same as, were punished the same as the first offenders. Those are common sense today in criminal law. That is not right, right? Therefore, you can see a persistent influence of criminology ideas and criminal law. Next. And the more important influence by criminology on criminal law is the criminal policy. This concept of criminal policy is was proposed by Friedreich and List. Particularly, List is extremely influential, and perhaps many of you, even social scientists, criminologists, has heard this famous phrase by the List that best policy, the best crime policy is the best social policy. So List is a jurist, is a criminal law scholar, but here you can see the criminologist ideas. And also you can see criminal policy changes as political atmosphere, political ideology, social economic situation changes. For example, in the United States, the increasing violent crime rates leads to a new social policy shift to getting tough criminal policy. And we can also see these shifts all over the world in many countries. Therefore, you can see the change in criminal law is actually influenced by criminology all the time. Next. And another thing is we have criminal justice organizations. We have courts, police, corrections. Every country has those institutions. But one thing that those institutions emphasize is not just carry out the idea of criminal law, like equal treatment or equal punishment and so on. They also emphasize, let's say, effectiveness. You have to pay money to run those organizations. Therefore, criminal justice study, particularly criminal justice evaluation study, becomes very prominent, particularly in the Western society, in Western countries. Evaluation involves sophisticated methodology to make sure programs that people propose under criminal policy work best. And there's numerous examples to see how evaluation studies become a central part of criminology and criminal justice research in Western countries. In the United States, as we know, that every government funded project must be evaluated. Otherwise, the funding cannot be continued. In many countries, that is how important it is, the evaluation research, which largely carried out by criminologists with empirical methods. The emphasis today, over the past 20 years, has been evidence-based policy. Right? These ideas are, clearly grew out of criminology research, applying criminology empirical methods. And these are the shortcomings of the Chinese criminology that we're going to turn to explain why Chinese criminology appear to have not developed as highly as we wished. Next slides. So we have several papers, books talks about Chinese criminology, and pretty much Chinese criminology had 3 stages generally believed, particularly after 1989, Chinese Society of Criminology and Chinese Society of Juvenile Delinquency Prevention Society established, but Chinese criminology, is established from that time, but not developed fastly. Next page. Okay. There are many reasons that China's criminology has not been grew faster. One of the things is that, I have some facts here to show you why we conclude it is not being developed fast. The publication number has not been greatly increased over 20 years and even 30 years. And also there is no the Chinese core journal, Chinese SSCI, CSSCI journals, right? There's no CSSCI journals as the core journal belong to criminology. All these reasons, next page. One of the major reasons that Chinese criminology has not been developed very well, in our opinion, is that because the disciplinary status is not really clear. Okay? As we can see that there's many Chinese ideas actually is consistent with criminology ideas. However, Chinese criminology does not have an independent disciplinary status. Next page. And also because in China, it's just heard Su's paper, right, about governance. As you can see, one of the major features in Chinese society is that government has to sort of like, in charge, taking over something then to make that grow, right? Criminology has not been considered clearly understood, as important, as important role as criminal law. Our observation is that. So therefore, there's not much of products supported by government. For example, academics products and crime prevention products. When those market is not strong, the criminology does not have a demand to meet. That I think is one of the obstacles for criminology to grow fast in China. Next page. However, you can see criminology developing in China from two perspectives. On the one perspective is the conceptual perspective. People do not have a clear idea about what criminology is. They believe criminology as assigned by educational ministry belong to part of the criminal law. So criminology has a lower status than criminal law. But however, in reality, as you can see, the Chinese political structure and social structure consider for a long time, for a long time, that it's not just a free will that drives people to commit crime, right? It is really the multi factors of social factors. Therefore, many Chinese criminal policy developed over years, shifts over years, actually emphasize criminology. So it is just conceptually, ideally, it is not officially recognized. Next slide. The main thing that leads to the underdevelopment of criminology in China is the lack of strong empirical methods applications. People do not have a lot of training in empirical methods. Law school rarely offers classes, and like in law exams, national law certificate exams, criminology is not part of it. There's many other reasons that leads to the Chinese criminology did not develop as fast as it should. Next page. Okay. So pretty much in future, I think there's a big room and big need for criminologists and criminal law scholars to collaborate in China. First of all, as I said, in China, one of the major things actually reinforced by Su's paper that you just heard, this social governance, narrative, the discourse. It's always the major discourse. And under that political and cultural condition, you can see criminal policy has been very important. Su also mentioned that, right? Therefore, this is really the job for criminology. On the other hand, under the criminal policy umbrella, criminal law, criminal justice studies, when they converge together to form a criminal policy, when they add to empirical methods to emphasize empirically based methods criminology can flourish. Okay. I'll end it here. Thanks for listening. Thank you. Next, let's invite Liang Bing to give his lecture.
Hello, everyone. I assume you guys can see my slides. It's my pleasure to join the panel and good to see old friends Su Jianhong and Eng Sheng as well. So I'm going to be try to stay within my budget time here. So I'll talk about 3 cases of compliance, and then I prepared this one as a way to expand a previous presentation I was given. So let me just provide a little bit of background information about my research here. So those 3 cases I will be talking about, Li Wenliang and Chen Qiushi. 3 cases all broke out last in Wuhan, right? Not soon after the pandemic started in Wuhan. So about those 3 cases, and when those 3 cases broke out, I became interested in those 3 cases, and then I started collecting data. Difficult time trying to find an angle where I can theoretically put those 3 cases. So we had a conference, Eng Sheng mentioned there's Association of Chinese Criminology and Criminal Justice. I'm serving as the president, so I feel obligated to mention the name once again here. So we held a first online conference in January this year. So that was the first time I presented my research on those 3 cases. At that time, as I mentioned, I was struggling finding an angle to put those 3 cases together. During our conference, we had 2 guest speakers. Dr. John Vasquez delivered his speech, and I was triggered. My further thoughts on this paper was triggered by this idea on issue of trust. So in this paper particularly, I will focus on trust as 3 different levels, and I will be talking about them. One is interpersonal level, the other level, social trust, and lastly, the public institutional trust. And then I'm also interested in government at different levels. So essentially the question is, how did the Chinese authorities at different levels respond to each of the cases in particular? And data, I collect the data based on open source data. I will be more than glad to elaborate those data I collected towards the end if I have time. So I'll be talking about literature, those 3 cases specifically, and then I'll try to put everything together in a theoretical framework of discussions. So the 3 cases here, in terms of the literature, there's a huge body of literature in the West talking about trust. And then people have different definitions as well. And most of the studies eventually pointed out political trust is a multi-level. And so for example, Downton pointed out that political trust can depends on the subject we're talking about, right? Either if we talk about a democracy as a, or we talk about the performance of a particular administration, or we talk about institutions such as court or police, or finally, we could talk about the actors of a political institution. So it could vary dramatically. Most of the studies, based on my review, focus on institutional trust. So 2 specific explanations or different angles have been proposed. The first angle is generally can be labeled under the institutional explanation. Essentially, the argument here is people's trust in public institutions is based on people's evaluation of the performance of the institutions. On the other hand, culture theories argue that each country, for example, China, could have a unique culture, political attitudes or atmosphere where those general culture impact could be independent to the performance of the institution, that those culture component could have influenced people's general idea of political trust. The past literature also digged out some unique features about Chinese components. So I'm going to highlight a number of them here based on what I read. First, it's very interesting that the research showed the trust level among Western democratic nations, democratic nations. China rather displayed a high level of institutional trust. So that's very interesting. And again, people try to study, scholars in this field try to attribute the high level of institutional trust in China to two different theories or explanations, as I explained earlier, either to the particular culture component in China, some examples including the paternalism in China, authoritarian type of regime in China, or the emphasis on harmony instead of conflict. Aspect of this, trying to explain the high level of institutional trust in China, trying to give credit to the high governmental institutional performance, especially pointing to the strong economic performance in the last 4 decades now. And a second feature in this field, studying Chinese trust, political trust, is talking about the so-called hierarchical trust. This is very interesting. Again, it's very different from, for example, in the US. For those who know a little bit more about US politics here, generally speaking, the trust level towards the central government, the federal government in the US is considerably weaker compared to the local government. But the thing in China is flopped. Study consistently show there's a higher level of trust towards the central government in China compared to the local government. Again, study show different factors. Some studies attribute this hierarchical trust to Chinese control over media, to its political strategies used. And then one study here also showing the Chinese central government is taking advantage of this hierarchical trust, a feature that actually loomed in those 3 cases I will be presenting later. A couple of other dominant features among studies of Chinese political trust. One is there is a big divide between the rural and the urban in China. And also some scholars emphasize the effect and seeing the stuff. They also, most recent studies actually show the Chinese government is very good at adapting different media functions or use of internet, newspaper earlier referred to that as a smart internet regulation or governance. So Chinese using a WeChat, for example, they have been adapting and increasing its capability of governing the society in such a smart way, if you want to call it that way. I did notice there are 2 different inadequacies in the past studies. One is those scholars admitted there is a strong connection between general trust and political trust, but very little study actually paid enough attention to empirically examining the interaction of trust. Second, most of studies based on my review are quantitative in nature. They rarely address the issue of governmental responses. Non-compliant cases were issue of crisis. So I'm going to turn to my 3 cases in some of the facts of the case. And the first case is probably the best known among the audience, I would assume, Li Wenliang. Li Wenliang was born in Liaoning province in 1986. He studied at Hunan University, and then he worked in Xiamen province for a few years before he joined the Wuhan Central Hospital. He also was a Chinese Communist Party member, and something that people often do not realize. Li, the event triggered his non-compliance occurred on December 30th, 2019. The next slide actually showed his WeChat message. Essentially, he tried to warn his colleagues about the pandemic coming up. But then that thing unfortunately triggered the censorship of WeChat function and triggered his further reprimand. So a few days later, and Li Wenliang was summoned by the Wuhan police, and they took him to a police station. He was forced to acknowledge his fault, and the police officially issued a, they call it admonition letter, and censured him for publishing untrue statement. Unfortunately, Li contracted the virus a few days later, and then he was hospitalized. It's very interesting during this case of hospitalization, when they treated Li, Li has transitioned from a private figure to a public figure. The Western media try to call him the whistleblower, but Li argued that what he said in his WeChat was not rumor. He specifically mentioned if the official has disclosed the information earlier, it would have been much better, right? So he also argued we need openness, transparency in society. A healthy society should not have just one voice. So all of those phrases become catchwords among the listeners or followers of Li. Unfortunately, Li passed away at the age of 33. His parents was contracted with the disease but recovered. He left behind a son, his wife, and gave a birth to a second son later. Here is the summary of the Li's WeChat message. So essentially, he was just warning people about the confirmed cases of SARS, and he's talking about could be a new virus there. Someone in the WeChat actually warned that be careful, otherwise this could be, our group could be shut down. And Li also mentioned himself that don't share information outside the group, just tell your family and loved ones to take precaution. But the message still leaked and went public very quickly. So there are three levels of trust, as I pointed out earlier. Li had his support within his inner circles. He was embraced by his colleagues, friends, and family members. He also accidentally, I would argue, become an icon of public trust. Millions of people followed him on his Weibo account, and people labeled his Weibo account as the Chinese virtual wailing wall. And people embraced Li for a number of reasons, as I listed here. He was definitely the frontline medical worker who died because of the pandemic. He also, to many, he was inadvertently become the whistleblower, even though that was not his. Then to many people, he represents the brightness and righteousness, and he dared to fight against the admonition. Also Li's appeared to be the normal guy, right? People made left comment on under his Weibo account because they loved the fact Li, it's just like a normal guy. He shared what TV series he liked, what type of food he liked. When he was allowed to have a second child, Li was very happy and openly acknowledged that. So people love him as a normal guy, sort of the household hero. So unfortunately, during this process, Li had become this symbol in a way, unintentionally challenging the institutional trust, right? Lack of transparency, broad police disciplinary power, as I put it down here. The governmental revisions, there are a number of things that the government took, different levels took, in order to revise, correct their mistakes in Li's case. So start with the Chinese Supreme People's Court weighed in and mentioned what Li and the other 7 people, actually altogether 8 people, what they have circulated were not entirely false. Therefore, should not rumors that should be regulated. And then later on, a few days later, the National Supervisory Commission, as NIC, announced its decision to invest Li's death. This happened on the day when Li passed away. And also, National Health Commission, along with Wuhan municipal government, to Li's family. At that time, Li has already become the household name, the national hero at this time. After the NSC released its report, the Wuhan police, public security police, essentially revoked its admonition, made apology to Li's family, and they actually sanctioned 2 officers. Now they have to be the scapegoat of the Li's incident. Li received a number of prestigious honors, including that he was, along with others, labeled as official martyr. And then later on, they also the National Intellectual Property Administration denied applications when a number of people tried to utilize Li Wenliang's name in their trademark registration for profit. So that was rejected by as a way to defend Li's reputation. Last but not least, there is a National Health Commission was drafting amendment to the law on prevention and control in infectious disease. One of the provisions is proposing to recommend awards be given to those individuals who reported potential infectious diseases. Even such reporting turns out to be not true, they shall not be responsible. So as a way, many people credit this to Li's incident indeed. The second incident is Chen Qiushi's case, which is lesser known because information about Chen was largely deleted domestically in China, especially in Wuhan. Chen became famous after he won the second place in a reality TV show named I'm a Speaker. So in particular, I become interested in one of his speech titled China. He did have a law background indeed, in case you didn't notice. So Chen mentioned in this particular speech, he's saying in the society of rule of law, law shall not instill fear, rather it is the law that should be caged. So he's talking about China put power in the cage and to be regulated by law. He encouraged people to embrace rule of law and mentioned specifically, if the spirit of law is surprised, no one should be safe, right? So in equality and justice, if you dare not come forward today, you won't have a chance to do it tomorrow. And so he also became controversial, as a matter of fact, after his reporting in Hong Kong in 2019. So he definitely became the thorn in the eyes of Chinese authority. His Weibo account was shut down. Instead, he turned to Western media, I should say, YouTube or Twitter instead. So what triggered this non-compliant behavior occurred toward the end of January 2020, after Wuhan, the pandemic broke out in Wuhan. And Chen arrived after the city on the last day, the city got shut down. He visited hospitals and talked to people there and tried to do citizens report as a result. But then his message was viewed as too controversial and challenging to the official message. And then he disappeared on the 7th of February. And later on, he was announced, his parents were notified that he was detained and in the naval quarantine. And then they refused to disclose where he was. And so only 6 months later, or actually more than that, roughly 7 months later, Chen was released, and then he was reported leaving family members in Qingdao in China. I cited here some of the Chen's message during his trip to Wuhan. So you can see, and he's trying to defend himself in a way, protect himself, given his law background. He's saying, I'm not going to spread rumor, right? So I'm not going to create panic in society, I only tell truth. On the other hand, he became increasingly critical, and he mentioned CCP's and then he's talking about encouraging everyone to step up, and then seeking truth, and then looking forward for more actions. And fortunately, his message was viewed as too bold and critical. Chen did have his trust support within his inner circles. I mentioned his family, friends. One of the known friends he had is Xu Xiaodong, is an outspoken martial art fighter. He had a boxing place where he sheltered Chen even today. It's very difficult to measure or gauge public trust to Chen's case. His message about rule of law, given his success when he won that second place with that reality TV show, seemingly that message was welcomed. But on the other hand, his visit to Wuhan, to Hong Kong, generated mixed message, especially the Chinese news outlet completely shut him down. So if you do a search, Baidu, search Chen's visit to Wuhan, you probably will generate nothing. So that shows actually the power by the Chinese today, social media included. So it's very difficult again to measure the gauge his support. the public or by the general public. On the other hand, his a progressive critical approach did become a challenge to the official message, just thus becoming a threat. And on the other hand, Chen was, in contrast to the fact that his message was shut down in China domestically, there were plenty of reports internationally about his behavior. And then, but on the other hand, my observation here is that his international appealing, his reputation as human rights lawyer internationally actually did not bode well to his own mission domestically. The last case is probably the least known case among three. So we have Huang Dong Yin, who is a female prisoner, 61-year-old last year. And he was sentenced to serve 10 years behind bars in 2013 for bribery. Her imprisonment was 10 years initially, and then she received 2 commutations. As a result, she was successfully released on February 17, 2020. So soon after, not too long after Wuhan pandemic got started. So Huang Dong Yin was serving time at the Wuhan women's prison indeed. And then the authority actually reported a lot of cases that were reported from the Wuhan women's prison indeed. So when she was due to be released, and the prison, actually officials at the prison made a deal with her family member, I will mention that later, and they delivered her to a toll station at the border of Wuhan, and then transferred her to her family members. The family members of her drove her all the way back to Beijing. And then the second day after Huang Dong Yin checked in, she had symptoms of the pandemic, the COVID-19 situation. She was immediately hospitalized, and then she was recovered after treatment. So the whole thing was viewed as a serious incident caused by dereliction of duty at the border. And so immediately the official at the central level, the government allowed official investigation. And then after their official investigation, they labeled it as a serious accident. They blame the whole thing to the provincial level of authorities, including the Hubei Bureau Prison and also the Public Police Division as well. At both the provincial level, Hubei and Beijing, their governments also took actions to do their own investigation. They tightened up their border control as a way to try to protect Beijing from being infected by inmates such as Huang Dong Yin. And then different measures taken, as you see here. I'm not going to go over them one by one. Some key officials now serving as the scapegoat being removed from their post. And then as a way to show, hey, the central government took actions, now things are corrected. We no longer need to worry about it. So in terms of the outcome to the Huang's family, Huang Dong Yin herself punished as a result. The official investigation found that she was not aware of the emergent situation because she was serving time behind bars. Her arrival created actually no actual risk. And even though theoretically speaking, you can argue it's probably posed the most serious issue to the public health. Those family members who pick her up at the border, including her daughter Tan and her ex-husband Yan. It's very interesting that they actually did all they can. Before they reach out to her, they actually called Beijing, talk about the feasibility. They were saying, hey, the prison reach out to us. We plan to go to the border, pick her up. Is it okay for us to drive her back to Beijing? The message it got actually from Beijing CDC was saying that was okay. So they actually received the wrong information, but they did not know. And they made the effort due to their family support. They reached out to, they openly welcomed Huang and brought her back Then both were actually quarantined and disciplined as well administratively. Public-wise, the case against Huang was unique in the sense they concerned about two things. One is they concerned about the breach of Huang's case could be indication of loopholes of the containment policy. They wonder how many people actually sneak out of Wuhan amid the tight lockdown, therefore being threat to public safety. On the other hand, they also made Huang's crime of corruption, the crime that pinned Huang Dong for her imprisonment and to her housing. They traced her the community they purchased, the flat they purchased in Beijing. Actually, they actually speculated on how market price is, and they argued that there's no way Huang and her would be able to afford the housing in Beijing. So they insinuated that Huang's corruption might have played a role in the process. Their suspicion, I would argue, their suspicion of the corruption and the powerful background, so to speak, attest to the severity of those issues in China, continuing that bothers people and then linger people in contemporary China. I don't know. I hope you guys can see this summary table. Okay, on my screen seems to be bigger than I anticipated. So essentially, I try to summarize those things here. So again, I try to analyze 3 different levels of trust, and then I try to address governmental responses at different levels. You can see the motivation part is different in each case. And for Chen Qiushi, the second case, he's trying to be progressive. He was probably posing the most challenge to the government, and then he was made this. On the other hand, medical-wise, Huang might be posing the challenge, but unfortunately, it did not become the issue. But then the fact that Huang trying to stay away from it turns out to be posing the least challenge to the government. Therefore, his case was let go rather quickly. Li's case was interesting in the sense Li Wenliang turned himself around from a private person to a public figure. And then it is also interesting to see that even though we have different levels of demand for transparency, there is a consistency for transparency, for more information. But unfortunately, you can see in those cases, the backbone of governmental response has always been information control and surveillance, right? So they are willing, the government at different levels show their willingness to deal with cases case by case in a piecemeal fashion, but the system of information control and surveillance, it is still there. So the overall, some overall lessons, also there's those 3 cases really, in my opinion, shows the complex interaction of trust issues at different. So this is, in my opinion, not well addressed by past studies, often based on quantitative studies. Rather, those individual cases, on the other hand, showed complex interaction of trust issues at different levels, and then shows also the governmental responses have been adapted and over time to address different needs and concerns and based on the nature of those cases. So even though the government, I would argue, as this literature also showed, Chinese citizens, now they want transparency, they demand also freedom of speech, but they are technically remain silent on other issues. They know where is the right line not to cross. My analysis actually shows that the people actually lend support to Li Wenliang, who is very mild, take on a very mild approach to the progress in China, in contrast to Chen Qiushi's more progressive approach. But Chen's case is very difficult, again, very difficult to gauge the public support in that way. Chinese authority, on the other hand, learn to be adaptive over time, and it is very flexible. They are willing to show their diligent work to solve individual cases. The quick response is part of their plan, I would say, to address those concerns over time. But at the same time, they also keep tight control over their system, the censorship, discipline power, even though those are all in the background of those three cases, very little can people do to shape pose actually changes to those issues. So the critique is also allowed at different levels of government. And if you recall the hierarchical trust reviewed by the literature, and the Chinese government, central government actually enjoys it seemingly, and willing to play the role of savior when there's issues occur, and they are willing to step in and then correct those mistakes made by the local government or local authorities, such as public police. And then they are willing to be responsive to the needs of the people in their own fashion. So there are limitations to my studies for sure, and all three cases broke out during the major pandemic. Therefore, the concerns about public health clearly a major issue among those three cases. May not be a major issue in other events. And also the role of some of the salient factors in past studies, such as economic performance or the divide between rural and urban, not relevant in my study because I only focus on two major cities. Cases occurred in Wuhan and Beijing rather than rural areas. My case selection is all three cases, as I mentioned, they occurred at the early Wuhan's outbreak. They all caught attention of the media. They all trigger sanctions and being because they are all non-compliant in their own unique ways. They all trigger disciplines by authorities. They are, I would say, the punishment in those three cases are very minor in a way. But they also all those cases showed actually how the Chinese government or authorities at different levels could respond to different challenges based on specific case scenario given different natures. So that would be the end of my presentation. I would at this moment I would give the floor to Dr. Ansheng Li.
Thank you very much, Professor Liang. It's always good to hear the developed version of your excellent research. And also thank Professor Liu and Professor Vasquez for their excellent presentation. So I'm just going to share my screen. Okay, so my topic today, I'm sorry, just trying to enlarge it. All right, okay. So my topic today here is bureaucratizing criminal convictions in China. So in this presentation, I'm trying to deliver an observation that the way criminal convictions are reached in China has experienced significant change, becoming more centralized, rationalized, and increasingly bureaucratic. It is mainly because there's been a large and visible shift in the Chinese criminal justice system from the old traditional version of what we called iron triangle towards the a more plea-based or confession-based form of justice, namely plea leniency system. And we would have we'll take a look at the concepts and the elements of the plea leniency in a little while. And as a result, the criminal conviction has become more like a product manufactured in the factory and delivered in the conveyor belt in order to save costs and time of case processing. But it's interesting to note that the official rationales for this new justice scheme are that this program is devised to promote efficiency and protect individual rights. So in this presentation, I am going to challenge these official narratives, and my focus here is on the second issue, which is the protection of individual rights in the plea leniency process. So for Chinese audience, I would just quickly mention that plea leniency in Chinese is 认罪认罚从宽制度. Okay, so let's just move on to the next page. So that's an overview of my study, and I'm trying to make a number of arguments here. just to give you the more specific picture. So there's been clear evidence of the changing pattern of conviction over the past couple of years in China, in the sense that the guilt of defendants is no longer determined by the judge after the proper trial, but instead it is determined by the prosecution without a trial. And it is mainly driven by the shifts from this iron triangle. So in Chinese, it's called 铁三角, towards a plea leniency system. And it then creates what I call centralized bureaucracy of the criminal justice, in the sense that all the major powers are concentrated in the hands of prosecution, including the power to investigate the case, the power to prosecute the individual, and the power to sentence the accused. As I just mentioned, so the government patterns is that this program is devised to promote efficiency and to safeguard individual rights. But unfortunately, my study indicates that that program is at odds with these official narratives, in particular in terms of the protection of individual rights. So the question here is, does plea leniency live up to its official rationales? And my answer simply is no. And later on, I will provide evidence to explain why I think in this way. Okay, so that's this overview of my presentation today. So for those who are familiar with iron triangle, for those who are familiar with the Chinese criminal justice system, the iron triangle definitely is not a strange expression. So it refers to the process in which police, prosecution, and court, so they work together towards the same collective goal, which is conviction. So it is particularly demonstrated by the fact that the conviction rates in China is always extremely high. It has never been below 99%. So in this structure, practical structure, instead of keeping each other in check, the police, prosecution, and the judge, they watch each other back, taking care of each other in order to make sure that the accused can be convicted. So the common way of doing that is to make sure that the evidence collected by the police can be always used by the prosecution to support the charge, and it can be then presented to the judge to justify the conviction. And during this process, this iron triangle process, unfortunately, the lawyer plays a very limited role in representing and defending their clients. Why? Because the Chinese criminal justice system, the entire Chinese criminal justice system, unfortunately, is not an adversarial system which advocates competition and a confrontation. But the evidence shows that in the last couple of years, or even the last decade or so, there's a clear move away from this iron triangle system and towards the more centralized bureaucracy of criminal justice, namely plea leniency. So the idea of the plea leniency, or the culture of confession in exchange of leniency, is not new. It's not a new idea. So it can be traced back to the 1950s and the 1960s, where the motto leniency to those who confess and the severity to those who resist was introduced by the government to encourage the defendants to plead guilty and to confess their crimes. Because the Chinese criminal justice system pursues conviction as its ultimate goal, so confession obviously is, let's say, the most useful or reliable evidence that can be used by the prosecution to secure the conviction. And the most importantly, it saves time. So over the last 2 decades, since 1990s, we see that the Chinese government put out several procedures in order to make sure that criminal cases then can be handled in a rapid fashion. And these procedures are all premised on the idea that defendants plead guilty and accept the proceedings, such as simplified procedure introduced in 1997 and a fast track procedure introduced in 2012. So all these procedures over time have paved the way for plea leniency to take place and to take shape. So in 2016, the Chinese government introduced the plea leniency system as an holistic approach to confession in the criminal justice by incorporating the simplified procedure and the fast-track procedure. And in 2018, so plea leniency was established as the formal institution of the criminal justice in China. So it is safe to say that plea leniency has now become the default practice of criminal justice in China. So if you look at the latest data released by the Chinese government, we see that the more than 85% of the criminal cases in 2020 would actually dealt with through this plea leniency process. So the next question is, so what plea leniency entails? Some of you probably have this question as to whether plea leniency is similar to the plea bargaining that we often see in the Western jurisdictions. So in some respects, they are conceptually different. So for example, under plea leniency, the defendants are required to confess their crimes and plead guilty voluntarily. And they are also required to agree upon the alleged charge and the criminal facts. And most importantly, they must accept the sentence recommended by the prosecution. Okay, so that's the key step. And it is stated in law that in each plea leniency case, the counsel presence or the legal representation is mandatory, which means before the defendants accept the plea leniency agreement, that's the mandatory requirement that there will be the defense counsel providing legal services or assistance to the defendants. So in order to make plea leniency work, so that program follows the model, as I call centralized bureaucracy of criminal justice, in the sense that all the important powers are actually concentrated in prosecution as opposed to police and judge. So these powers include the power to carry out criminal justice, also the power to supervise the way criminal justice is carried out by the prosecution. So for example, in terms of investigation power, so we know that the police used to exercise the investigation power, but a plea leniency, it's a bit different. So the prosecution are now required to set out the direction for investigation for the police and guiding the police to collect evidence and to determine criminal facts through the program called early intervention, 提前介入. So I think the purpose of doing that is to avoid delay in investigating the case and an inconsistent evidential threshold between the police and the prosecution. Okay, just trying to save time and the resources. Another example is sentencing. So we know that sentencing used to be within the province of the judge. So the judge have these discretion to decide what is the appropriate sentence. But in plea leniency, it's a bit different because the prosecution are now required to make sentencing recommendations to the court based upon the fact that the defendant plead guilty. Having said that, it is not mandatory for the judge to accept the recommended sentence, no, but again, so the official data released by the government indicate that a vast majority of plea leniency cases, so the court just simply accepts the recommended sentence without adjustment. So overall, it's safe to say that the prosecution during plea leniency process, enjoy the pretty wide discretion in terms of investigation, prosecution, and the sentencing. But it's also important to know that it is not unreasonable to have the exercise of these powers unchecked all the time. So we see that the power to supervise the way the criminal justice is administered by the prosecution is also in the hands of prosecution. So in each prosecutorial department, we see that the prosecutors are subjected to a spectrum of rules and the guidelines to ensure that they exercise their powers as directed and not out of control. So we see these managerial initiatives that includes a lot of programs, such as supervisory programs, such as the performance assessment, such as the accountability system. So I'm not going into details, but what I'm trying to make the point here is that, this managerial model is aimed at regulating the way prosecution perform their legal duties during the plea leniency process. So here comes the last key question, which is whether plea leniency lives up to the official rationales. So we know that in criminal justice system, in criminal procedure law and the relevant judicial interpretations, we see that the plea leniency is designed to increase efficiency and to safeguard individual rights. So as I mentioned before, my focus here is not on the efficiency, because to study efficiency requires comprehensive empirical study, within China, which is nearly impossible at the moment, given what's happening around the world. And if we look at the study conducted by the Chinese scholars, so we see that there are mixed findings as to whether plea leniency has increased efficiency or actually decreased efficiency. So my focus will be on the protection of individual rights. And I think it's much easier, just to look at this issue with the current research methods. So in order to answer that question, I reviewed more than 13,000 court judgments from the basic level and intermediate courts in an Eastern Chinese city in 2020. And also I conducted an interview with the defense lawyer within the same city, just to ask about their experience, involved in when they involved in the plea leniency process. And finally, I draw on Tom Tyler, the American criminal lawyer. Sorry, he's a professor of law. He's not exactly a criminal lawyer. So his theory of the procedure justice to ask whether plea leniency, that process is fair and just enough to protect individual rights as officially advertised. I think it's very important or the imperative to just give a very brief introduction to the theory of procedure justice. So procedure justice, according to Tyler, as a theory that can be used to increase the public compliance with law and legal authorities. So it is very important for the legal authorities to work on these four particular things, voice, neutrality, respect, and trustworthiness, in order to increase the public satisfaction with the decision made by the legal authorities during the process of law enforcement activities. So voice means that legal authorities ought to give the defendants or to give the individuals the voice during the process. They need to let them tell their side of the story. Neutrality means that the authority figures need to be seen as neutral and disciplined decision maker, applying the laws and the rules consistently without discrimination, without the bias. Okay. The respect means that the legal authorities need to treat the individuals with respect, dignity, and courtesy. And the trustworthiness means that the authority figures need to be seen as people with trustworthy motives, meaning they need to listen and care to make sure that they doing the things right for everyone involved in that process. But unfortunately, in my study, my findings discovered that all these four key components are kind of lacking in the process of due process. Sorry, in the process of plea leniency. So in terms of voice, for example, based on the interview with the defense counsel, you see that the defendants are given very little opportunity to tell their side of the story. During the process, it's always the prosecution dominating the whole process. And unfortunately, the defendants, the defense counsel, they played an even more limited role in plea leniency process compared to the old, iron triangle system of criminal justice. And if we look at the court documents, we see that very few documents actually involved the count of facts from the perspective of the defendants. So all the papers, all the documents, and just describing, the facts, the criminal facts from the perspective of the prosecution. So there's no voice, involved in the process. Neutrality is also lacking in the sense that plea leniency, if we look at the application of plea leniency across the country, you see that plea leniency applies primarily to minor offenses, punishable by 3 years of imprisonment or less. In other words, the more serious offenses or extremely serious offenses are left in the court. It proves that there's no consistent the standard practice of applying plea leniency to different types of the case across the country. And if you look at the sentencing outcomes, we see that the sentencing outcomes vary from case to case, from crime to crime, from region to region. Okay? So there's no neutrality element existing in that process. So respect, no, it's also missing. Why? Because pre-trial detention is still used as the most commonly practiced measures in the process, despite the fact that the most defendants then actually charged with quite minor offenses. Trustworthiness, no. Why? Because we understand that in the plea leniency system, so what's the defendants need or the biggest benefit that can be gained by defendants by pleading guilty is to receive a reduced sentence. But my findings indicate that, again, most defendants, they actually receive the jail terms as opposed to community-based penalties, despite the fact that, again, most of them actually charged with pretty minor offenses. Okay. So I'm just going to summarize and conclude my presentation by saying that, there are a couple of observations I'm making over the last couple of years in the Chinese criminal justice system, which are first, there's a clear shift of the pattern of convictions in China. And it is mainly because the advent of plea leniency in the Chinese criminal justice system taking place and kind of taking over the old traditional version and conventional style of criminal justice iron triangle. But unfortunately, this new practice, or I call it centralized, the bureaucracy of plea leniency is at odds with the human rights protection. So it doesn't actually meet any basic requirements of the individual rights safeguard as called for by the government. So there's a clear gap between the policy and the practice. Having said that, the emergence of plea leniency that actually makes it more difficult for the accused to seek procedural rights. But in the meantime, it makes it easier for the authorities to seek conviction, which is consistent with the underlying value of the Chinese criminal justice system. So to a large extent, it resonates with the global trend of the of criminal justice system becoming more bureaucratic. That can be referred to as the administratization of the criminal convictions, according to the American criminal lawyer Maximo Langer, who published an article in 2021 on plea bargaining, not plea leniency, plea bargaining in some selected Western jurisdictions. Okay, so that's my presentation, and I think it's time to just open the floor for questions you may have regarding all the presentations that our speakers have made. Okay, all right, thank you very much. Okay, so we got a couple of questions, I think. I'm just stop sharing. Okay, so we got the first question for Professor Liu. Osma, sorry if I pronounce your name incorrectly. Osma asked, predictive policing is increasingly used by the MPS. I I think it refers to Ministry of Public Security. So how, in your view, will such new ways of policing be evaluated? So that's the question for Professor Liu.
Could you repeat the question again?
Okay, so the question is, so it's not written here, right? Okay, so predictive policing is increasingly used by the police in China. So how, in your view, will such new ways of policing be evaluated? I think, so Osman is just asking, what do you think of the, the use of the predictive policing or preventive policing in China? I think, yeah.
Okay. In my personal opinion, I mean, like these actions, these measures have both advantages and disadvantages. Yeah. Advantage is that I think taking crime prevention as important task, important goals of criminal justice system, rather than centered on punishment, like in traditional criminal law. A disadvantage is that when you predict something, you have a risk of making a mistake, right? So we have to really carefully design the predictive policing. What kind of instrument should we use to predict something? How about the validity and reliability of those instruments, right? And I mean, from what I observed, we don't have much of those scientifically based, evidence-based, tested, reliable instruments. Therefore, we need to improve on that. I mean, what we should do is to continue to stress crime prevention. But on the other hand, the tools that you use has to be, evidence-based. Should not be just a rough idea. Could be having many other problems, particularly when you predict something, you punish something, or you mark something as dangerous. There's a relevance to like protection of rights. So you have to balance this kind of policies. Okay.
Thank you, Professor Liu. So we got another question from Cynthia. I'm not sure if you are my student or not, but the name looks familiar. So you're asking how to compare plea leniency with plea bargaining. I think in so many ways they're different. So in terms of plea bargaining, I think the defendants, the defense counsel, they do have some sort of leeway as to negotiation with the prosecution about the charges and the sentence. But in terms of plea leniency, unfortunately, the Chinese defendants, they just don't have that much power to negotiate with the prosecution. They would just have to accept the deals and the offers made by the prosecution on the table without any negotiation powers. So I think that's one of the major differences between them. And then if you look at deeper, the underlying values of the Chinese criminal justice system and the US criminal justice system, for example, the US systems, I think one commonality, of course, is trying to increase efficiency. But as I said in the presentation, it is not certain, the certainty of the increase in efficiency is really questionable. But the other thing is that I think the plea leniency is really something that, because I haven't covered that part, but I think the plea leniency is really something that the Chinese government, they're trying to make sure that the conviction can be more easily reached. And it is not really to protect, individual rights. But on the other hand, I am not saying that the plea bargaining, in the process of plea bargaining, there will be much protection of individual rights. So I think you can't compare plea leniency to plea bargaining, given there are so many differences in terms of the systems, Western criminal justice and Chinese criminal justice, and some even political considerations behind it. So Sue has a question for me. Yeah.
Can you hear me?
Oh, yes, I can.
Oh, may as well just rather than typing it. Look, thank you for that wonderful presentation, and it was really interesting. I'm just wondering, when you had a slide about centralization of the bureaucracy. So I'm just wondering, what do you mean by the center? Who are the center that you're talking? What is the center that you're talking about?
It's the prosecution. I think this just everything, all the powers that are concentrated in the hands of the prosecution.
Oh, so
yeah.
Okay. So concentration rather than just central, like not saying it's going up to Beijing, it's centralized in Beijing, but saying it's kind of a concentration.
Yes,
okay.
just within the prosecutorial department, it's centralized power. Yes.
Yeah. Thank you.
Thanks.
Yeah.
Thanks. We have more questions. Okay. Thank you. Steve. So any other questions? I think we right on time. It's 1 o'clock. So if you have any questions, I don't know how the other ways for you to address those questions, but yeah, thank you very much. Yes.
If you don't mind, I can ask a question. So Sue, I have a question for you.
Yes, please.
I wonder, I agree, I concur with your assessment on the difference between the free comprehensive management used in the 1980s versus what is today. I'm just curious, I'm a little bit concerned about what you mentioned, the leading over everything, because we need to see everything first, right? So we can lead through everything. So I wonder, do you see, based on your research, any pushback from China? From time to time, people express concerns about privacy, but clearly they're not as long as what we witness in Western countries. And also the concept that, small government, or even Chen Qiushi's argument, as what I presented, talking about we need to put the government into the cage, right? The rule of law is not letting the central government having power, veto power. And so I wonder what that type of, did you run into anything like that, or you don't see this culture being cultivated and generated in China? So your thought. Thank you.
Yeah, thanks a lot, Ben. Yeah, thanks. I'll just be very quick because I can see something in the chat saying we need to wrap up the session. It's already 1:05. Yeah, pushback. Now, probably not, because if you want to push back against something, you need an avenue to push back. And since the censorship of the internet's been totally totalized, really, it's very hard to push back. Having said that, there are privacy laws that are being rolled out into 2021. So there is I think some recognition by the party state that there needs to be some kind of limitations on this, but in terms of organized pushback, none, because in part because a lot of people actually like the idea that that surveillance is protecting them, but at the same time, if there was pushback, we wouldn't be able to see it anyhow. Yeah, or they wouldn't be able to do. There's no avenue in order to organise collective pushback. That's what I'm saying. Yeah, and if there was, we wouldn't see it anyhow. Yeah, that's all. I better finish there because I know we're over time.
Okay. So yeah. Okay. So I think that concludes today's session. Thank you very much. Thank you, Professor Liu Jianhong, Liang Bin, and Sutra Vasquez. Thank you very much for joining us today, and excellent presentations. Thank you. I hope to see you soon.